We believe this hearing is long overdue. In fact, the last FEC oversight hearing before this commission was in 2004. 7 years is a long time to go without an oversight hearing on an agency with such great consequence to political discourse. There has been a breakdown in this committee's oversight responsibility, and it's been a bipartisan one. That's time for that to change now. This past summer, the committee presented the FEC with questions pertaining to agency operations, regulations, and litigation. Putting partisan conflicts aside, we want to explore the practical functionality of the agency, how it works can impact political speech, and overall disclosure. It was a long list of questions. We had a great deal of catching up to do, and I appreciate the FEC's responsiveness to our inquiries. There have been some positive accomplishments, particularly in providing more due process for those dealing with the FEC. However, I found some of the answers to be troublesome and others that perhaps just led to more questions. For instance, why is the agency continuously pursuing litigation based on legal principles that have been rejected in case after case? This constant pursuit to litigate losing cases again and again, I believe, is an indefensible waste of taxpayers' money. Or why hasn't the Commission updated regulations that are unconstitutional after a ruling by the Supreme Court in January of 2010? Federal general elections are just 12 months away. Campaigns and independent groups are in full operation, and the Commission's regulations are not up to date. How much will candidates spend figuring out what rules to follow and what to do? And finally, why, when asked by this committee, did the Commission refuse to provide a copy of several enforcement documents? Why is the Commission withholding its RAD review and referral procedures, its enforcement manual and updates, and its penalty formulas? From what I understand, the enforcement manual is similar to, for instance, the SEC's enforcement manual for staff investigations, the Department of Labor's manual that explains its investigative authority and procedures, the U.S. Attorney's Manual outlining the Justice Department's enforcement policies, the DOJ's Antitrust Division's Manual, and the U.S. Parole Commission's Manual, to name a few, and there are more. They are similar in that they all provide their respective staffs with guidelines and thresholds necessary to enforce compliance with federal laws and regulations. But there is one major difference. Theirs are public, and yours is not. Instead, you deem yours as a sensitive internal document, and I have to ask how you can justify that. Just this past January during a commission meeting, Commissioner Weintraub noted that promoting transparency is essential to the Commission's mission. She said, and I quote, "We don't believe in doing things in secret." And I have to ask, what is the definition of secret? Unlike the FEC, other agencies rightfully make their manuals public to help those trying to comply understand the standards and thresholds that they will be held to. Shouldn't everyone subject to your investigations and penalties have those same rights? Your unwillingness to release these documents contradicts and ultimately hinders your agency's core mission. And I think it puts us in a situation of, are we really going to be transparent? It's unacceptable, and I believe it needs to change. And that's why I'm going to ask again. This committee is requesting that you provide us with your RAD manual, your enforcement manual with all updates, and your penalty formulas for regular and administrative fine proceedings, all within 10 business days. Furthermore, we request that you establish agency procedures to make all of them publicly available. To be clear, this is the second time that we're asking, and I believe it is the last time that we will ask. The third request will be in the form of a congressional subpoena, and we know we don't want to go there unless we just have to, but we will. I understand that there are policy disputes over some of the regulatory progress at the agency, but what we are talking about here today are operational failures. What disservice is the Commission providing when it doesn't even update its regulations to reflect current law? And how can we trust an agency to enforce disclosure when it lacks disclosure? As I mentioned, this agency's actions are of great consequence. The laws it enforces are limitations on political speech protected by the First Amendment, which is why it is imperative that they be enforced in a fair, consistent, and transparent fashion. Again, I do thank you for being here.